these rights unless certain formalities have been complied with. So the key point is, where somebody is a worker, it's not possible for an organisation to exclude these rights, whether in a staff handbook or well. I was going to then briefly refer to Edwards and Skyways on the issue of intention to create legal relations. And in the copy that's just been handed up, Edwards involved a collective agreement between BALPA, the pilots union, and the employer, and there was an agreement that if pilots were made redundant, the employer would pay sums in respect of their pension contributions. And the issue is framed at page 902, and it's the last 3 lines of 902. And the issue in the action is whether, as a result of what was agreed at the meeting, the plaintiff, when he decided not to accept offered alternatives, that's alternative employment, but to leave the company's service and withdraw his own pension contributions, whether he acquired a legal right to be paid by the defendant company a sum equal to the contributions which they had paid to the pension fund on his behalf. Plaintiff says there was a legally binding contractual right. Defendant companies say, while there may have been a moral right or an obligation binding in honour, there was not a legally enforceable right. And court goes on to deal with that at 904. You'll see the sidelining there. I'm not asking the court to read it all, but from H to the bottom of the page, it's from the judgment of Lord Justice Atkin in Rose and Frank. If I could invite the court to read H to the bottom of the page.
Well, it's really from the beginning of the sideline, isn't it? D, that it's in domestic social relationship, there's a strong presumption against, and with a business affairs relationship, it's the other way.
My lord, yes, and just to round that off at 905, again, it's between A and B. The subject matter of the agreement is business relations, not as social domestic matters. Meeting of the minds, an intention to agree. There's admittedly consideration. Justice McGaw accepted the proposition that in a case of this nature, the onus is on the party who asserts no legal right, legal effect was intended, and the onus is a heavy one. We say that applies here. Lord, next, just to briefly consider the volunteer cases, also a few of the volunteer cases, and perhaps just to clarify our position, just for the avoidance of any doubt. Appreciate there's some questions at the end of yesterday. We do not say that the true volunteer cases are wrongly decided on their facts.
Sorry, say that again.
We do not dispute that the true volunteer cases have been wrongly decided on their facts, in the sense.
Assert that they've been wrongly used. You do not assert that they've been wrongly used.
We do not suggest, no. And properly, although we do suggest that some of the reasoning no longer holds good, or some of the rationale no longer holds good, properly analysed, each of the cases can largely be understood on the basis that there was no right to remuneration, only expenses. And therefore, in the absence of valid consideration, the services provided amounted to a gratuitous gift. And my lord, the reason why we say that there's no valid consideration is because all of these cases can be analysed through the first limb of ready-mix concrete, the agreement to provide one's labour in exchange for remuneration. And that is how the consideration has been understood and applied in these previous cases. There must be a wage or other remuneration. Next, none of the previous volunteer cases address the status of a worker engaged on an intermittent assignment. And the next point is, following match officials, it can be seen.
Sorry, Mr. Britton.
Sorry.
Go down a bit.
Sorry.
Yes.
Yes, and the fourth point is, following match officials, the reasoning in some of these older cases it no longer holds good, because they apply the wrong concept of mutuality of obligation, or at least they apply a test of mutuality needed to establish continuity of employment in an overarching contractual relationship. So, for example, to establish continuous service to bring a claim for unfair dismissal. It's a 2-year qualifying period. And the fifth point to highlight is at least...
Sorry, it occurred to me last night. We were told yesterday, I hadn't noticed because I hadn't read the papers carefully enough, that Mr. Groom was originally asserting that he was an employee. The unfair dismissal claim was struck out by Employment Judge Christensen on the basis that it was out of time, but it was bound to fail anyway, wasn't it?
My lord, precisely, it was bound to fail on the it could only have succeeded on the basis of an argument advanced on the basis that he was engaged on an overarching contract. And we know that, as below, it was only the case was only advanced. He was engaged on an intermittent basis. He was a worker each time he attended for training or duty. Lord, apologies, I can't remember if I've got to my fifth point, but
you had, but you didn't say what it was going to be.
3 of the cases also have something to say about intention to create legal relations, albeit limited to payment of expenses. And I'll draw that out, but effectively they do say that where there is an agreement to reimburse expenses, that's a strong point, and there is an intention to create legal relations. We say, if that applies to remuneration, pay for hours worked, the inference must be much stronger. And just to address the court in respect to a few of the authorities, the first one is Divide 11, page 184. And we did look at this, my learned friends took your lordships to this, and I just want to highlight one particular passage because my shortcut yesterday didn't bear fruit. But this is Murray and Newham Citizens Advice Bureau, and your lordships will recall the tribunal found there was no contractual obligations. The EAT found that the tribunal erred in that regard. The key reasoning that you've already been taken to is at page 187. And not wishing to dwell too much, because your lordships have already been referred to this, at paragraph 12, this is the key passage dealing with contractual nature of the agreement to pay expenses. And you'll see that counsel for the appellant pointed out if the applicant or anyone having incurred expenses either travelling to work or while at work for the Citizens Advice Bureau under such an agreement were not reimbursed, those expenses in accordance with such with the document, then an argument that he or she did not have recourse to law because sums were not due under a contract or damages for breach of contract would be unsustainable. We therefore conclude that this tribunal has simply failed to understand the law or apply the proper legal principles. Now, that was the passage that I paraphrased yesterday, but the key point is this. It's precisely the same analysis must apply to Mr. Groom. He's entitled to both expenses and remuneration. And paragraph 12 can only be understood on the premise that all of the components of a binding contract, offer, acceptance, etc., and consideration and an intention to create legal relations are present. But the key point is, on the basis of paragraph 12, if there's a contractual entitlement to expenses, it must also extend to remuneration in the form paid to Mr. Groom. Grayson, the next authority, that's divider 12, page 191. And at page 197, paragraph 12, three lines below F, Ms. Justice Reimer states, as volunteers, they provide their services voluntarily without reward. As a consequence, they're entitled to withhold those services with impunity. And then just by H, in our view, it's necessary to be able to identify an arrangement under which, in exchange for valuable consideration, the volunteer is contractually obliged to render services or else to work personally for the employer. But the key point is there, I think my Lord Justice Bean highlighted this yesterday, the key theme in Grayson is one, the lack of remuneration, and as a result of that, a consequence of that, there is no valid consideration. Page 198, paragraph 15, the EAT consider the language of the agreement in the volunteer handbook, and at F concludes that's not the language of contractual obligation. If we scroll down to about 4 lines from the bottom of that paragraph, they will ordinarily be expressed in terms of unqualified obligation, or at any rate, the primary obligations will be so expressed, in particular those relating to the employee's hours of work and his reward for it. Now, pausing there, yesterday, my Lord Justice Smith asked what point I was making as to the significance of the wording in the Code of Conduct and the handbook, aside from it using imperative or directive language. The key point is this: when read against the last 3 lines of paragraph 15, the primary obligations relating to hours of work and reward, and what Mr. Groom must do or not do to receive that remuneration are sufficiently clearly spelt out in the documentation.
They're stated in absolute terms.
In terms of the right to remuneration, yes, they are stated in absolute
But
terms.
they're stated in terms of unqualified obligation. Is your point?
The volunteer handbook is very much in the language of expectation and voluntary commitment, but the remuneration document, you would say, is pretty hard-edged.
Yes, I'll go a stage further. The code of conduct, we've looked at it a few times.
And the code of conduct.
Capital letters must, in terms of minimum attendance, and it warns the reader or the CRO that if they don't comply with that, then their membership is liable to be terminated. And then, still staying with Grayson, page 199, paragraph, it's the latter half of paragraph 16, just below C, the most striking pointer against it being such a contract is, of course, the volunteer is not paid for his services. While he is reasonably expected to put in at least 6 hours a week, he's not in fact obliged to put in any such hours. He is not paid for such hours as he does put in, and the agreement identifies no minimum number of weeks per year during which he is expected to put in those minimum hours.
Give me, where are you?
Sorry, my lord, that's page 199.
Yeah.
And it's just below C.
Most striking point,
Against it being a contract, is that he's not paid, and the agreement identifies no minimum number of weeks, and he's not paid for such hours as he does work. And the key point is here, we are a world removed from that, on the basis that, as we've discussed, the code does set out minimum attendance requirements, and the remuneration, the terms are crystal clear in relation to that. The next point, paragraph 17, refers to the consideration that the tribunal accepted in relation to payment of expenses and insurance cover. Paragraph 18, the EAT say we're prepared to accept that this element of the agreement and also the provision in it to the effect that the Bureau will indemnify advisors against negligence claims by disgruntled clients probably do, or at least may evidence, a binding contractual relationship between the Bureau and the volunteer, namely a unilateral contract, refers to an if contract. Appreciate that's somewhat qualified because it's just as Rymer says, it probably does, or at least may evidence a binding contractual relationship. But the key point is this, and I don't want the risk of repetition. If payment of expenses probably does, or at least may, evidence a binding contractual relationship, the same must apply to payment of remuneration in the form of an hourly rate of pay. And then lastly,
but why
sorry,
isn't the key point that even accepting that, as you said in the last 3 lines, that contract is still not one which imposes a volunteer any obligation actually to do any work in the Bureau? You may say that's been superseded by subsequent authority, but in the thinking of that judgment, the key point is the last 3 lines, isn't it?
Well, my lord, in my submission, what paragraph 18 is doing is drawing a distinction between, well, one, there is a contract to cover indemnity, to cover the expenses and provide the indemnity, but second stage, how is that contract to be analysed? Does it fall within the field of work? No, it doesn't, because
it's not a contract that imposes an obligation to do any work.
Yes, there's applying that aspect of mutuality of obligation needed for an overarching contract. It won't be a contract which falls in the employment field. And then linked to my lordship's point about mutuality of obligation, paragraph 21. And 3 lines down, the EAT asks, but whether the volunteer agreement imposed a contractual obligation upon the Bureau to provide work for the volunteer to do, and upon the volunteer to personally do the work for any work, do to do for the Bureau any work so provided being an obligation such that were a volunteer to give notice immediately, the latter would have a remedy for breach of contract against him. Again, we say that's the outdated application of mutuality of obligation, one needed to establish continuity of employment to bring a claim such as unfair dismissal. That's been superseded by match officials and the reinstatement of the first stage of the ready mix concrete test, that all that's required is performance of work or service in exchange for a wage or remuneration.
Go.
Well, forgive me for being so slow. Do I understand your case to be that while you accept that in general terms there's no obligation for the person to respond to a particular call or to go to a particular, when they do, at that point, because there is an entitlement to remuneration for their participation, at that point you have mutuality, you have a contract which you say satisfies the terms of 230.
My lord, precisely.
I got it right.
Precisely, yes.
That's encouraging. Thank you.
And you say that what's said in paragraph 21 makes clear that what is being said at the end of paragraph 18 about there not being any obligation actually to do any work for the Bureau is a reference to not being obliged to turn up, as opposed to not being obliged to do anything when they're there.
Lord, yes, precisely. And what these cases do not consider is the status of the individual when they're actually at work on an episodic or intermittent basis. They say nothing about that.
Could I ask? I know you're representing just Mr. Groom, who was among the 2/3 of CROs who did claim. What about the ones who never claimed?
Well, Lord, for the purposes of what we say, that the focus has got to be on Mr. Groom and his situation, and the fact that he does claim. If someone chooses not to claim, that's their choice and their election. But
Are they workers?
Lord, I'd say that they could be workers and they could be entitled to the minimum wage.
Surely you have to say, or do say, that they are. You say that the same contract is in place. They just simply don't enforce the contract so far as it goes to their information.
Lord, yes, it would be that if they are aware that they're a worker and they don't claim their payment, that's a matter of...
It doesn't matter if they're aware, does it? On your analysis, they carry out work for which they're entitled to remuneration. You say that's mutuality of obligation. There is a contract. And so the difference between Mr. Groom and someone who doesn't claim is simply that the person who doesn't claim, for whatever reason, and there's a reference in the ET judgment to it being administratively burdensome because of tax implications, but for whatever reason, they've got a contract, but they choose not to enforce it. There's still the same mutuality. That must be your solution.
That has to be right, yes. And it is. It would be no different to, in a different setting, someone who would qualify as a worker, for whatever benevolent reasons they decide not to submit a timesheet or an invoice, which is a necessary step to trigger the payment. They're still a worker, but they don't.
And that would be the case if the evidence were that all bar one of the CROs never claimed the money at all, and there was only one who insisted on the entitlement.
Lord, yes.
Lot's wife.
Well, the final case to turn to very briefly is in Divider 13, page 202, Melthwish and Redbridge Systems Advice Bureau. I'll be take this rather shortly. This was an unfair dismissal claim. So the claimant in that case had to establish that he was an employee and had continuous service for the tribunal to have jurisdiction. Tribunal found that he wasn't an employee. And just to focus on a few passages from the judgment of Mr. Justice Burton, paragraph 3, you can see in the first line, the fundamental point, which was never an issue, was the appellant was a volunteer and received and was entitled to no remuneration. So that's the key point there. Then moving on to paragraph 10, page 203. Again, this features again the unquestioned position that there was no remuneration. Although the appellant was entitled to take part in training which was provided, which was of some benefit to him, without some benefit to the respondent, that is the only additional matter apart from the reimbursement of expenses upon which the appellant relies to support the case. It is plain that he was, on any basis, a volunteer worker. And then 16, just for noting, in the respondent's notice, they raised an issue with the tribunal's finding that there was a contract between the parties, and you can see the point raised by the respondent in the indented text. Insofar as the tribunal's conclusion there was a contract between the parties went beyond concluding there was a contractual obligation in respect to expenses, the respondent contends the tribunal erred. So what the respondent there was saying is, okay, it accepts there was an intention to create legal relations in relation to expenses, but nothing further. So, and we'll come back to see how the Employment Appeals Tribunal address that in a moment. And then at paragraph 21, the EAT cite from the prior decision of Prior. And rather than me reading out, I invite your lordships to. Actually, no, it's a lot of it's sidelined. But if we go to paragraph 21 and internal paragraph 9 of the EAT's decision, about halfway down the first paragraph, Mr. Justice Burton says, but plainly provision of a benefit to another party is not enough to create a contract. Would amount to the gratuitous gift of services or goods and not a contract if it arose.
So sorry, I can't. It's the fault of Burton J, whose paragraphs were interminable. But where are you reading from?
My lord, so paragraph 21. It's the first indented paragraph below that. 10 lines down.
Oh, but plainly.
But plainly, the provision of a benefit to another party is not enough to create a contract, would amount to a gratuitous gift of services or goods and not a contract if it arose out of the simple provision of a benefit to another party. There has to be mutuality to any relationship in order to create a contract. Receipt by one of those two parties of a benefit is not sufficient. There must be a promise in return. I will give you something in return for your services. There is, it seems to us, no such bargain in this case, no such mutuality of obligation. Sorry, I should have said that was the General Secretary of a football club who was found to be a volunteer. And then over the page, if I call it the second paragraph down, you'll see the reference to ready-mix concrete and first point, the servant agrees that in consideration of a wage or other remuneration, he'll provide his own work and skill and performance of some service for his master. And Prior, just like Mr. Melhuish, did not satisfy that condition. Therefore, that's why he was a volunteer and the tribunal had no jurisdiction. Paragraph 23, citation from Grayson. But just returning to the point about intention to create legal relations, I invite your lordships to consider paragraph 24. Where the EAT says it's satisfied that there was no contract at all here, contrary to the view, if such there was, of the Employment Tribunal. Then it deals with the objection and the respondent's notice. 4 lines down, all there is what Justice Reimer has referred as an if contract or a limited unilateral contract, that if the appellant attended, his expenses would be reimbursed, such that he could have claimed any unpaid expenses in the county court. And again, essentially, it's the third case where there's a trilogy of cases which confirm that an agreement to pay expenses to someone who is a volunteer does give rise to a contractual entitlement, or there is an intention to create legal relations. It may not be an employment contract, but it can be found a claim in the county court. And again, we say if that reasoning applies to expenses, it must apply to remuneration. And for that reason, the tribunal's stark conclusion that there was no contractual relationship at all in any way, shape or form between Mr. Groom and the MCA is unsustainable. Just turning very briefly to the final observations in respect, or submissions in respect of ground 1 before I move on. In relation to Mr. Groom's status and whether or not a contractual relationship exists, on these facts, here's a question of the interpretation or construction of the documents. The provisions governing minimum time commitment and in particular remuneration are set out in writing. And as regards the terms relating to remuneration, not going to say that they are an exclusive memorial in the Carmichael sense, because hardly any employment contract contains absolutely everything, but they are near enough. All of the terms relating to remuneration are sufficiently set out in the documents. And as the exchange between Lord Justice Popplewell and my learned friend yesterday, going through the tribunal judgment, there was really, in essence, precious little additional evidence considered or recorded by the tribunal, which, in relation to entitlement to remuneration, which went beyond the documents that we considered. There was mutuality of obligation, as now understood in match officials, provision of personal service in exchange for remuneration. The 5th point, the last point, on any objective analysis, there was an intention to create legal relations. In light of the 3 cases we've referred to, it would be surprising, an anomalous result, that there would be an intention to create legal relations in relation to reimbursement of expenses but not remuneration. That would be illogical. Lords, I move to ground 2. And in relation to ground 2, the MCA says that only a bilateral contract can qualify for worker status under section 233B, and that all unilateral contracts are excluded. Just pausing there, the anterior question is whether or not the relationship between Mr. Groom and the MCA is a unilateral contract. We say not. This is an entirely different situation to paying someone to walk to York. In the York example, there is an offer. The offeree is under no obligation to perform or provide to walk to York, or to provide any promises in return which are capable of acceptance by the offerer. Here, we're far removed from that. A CRO applies to the MCA for a position, is interviewed, is invited to join, they are enrolled, they undergo training. In the first year, I think it was 80 hours, maybe wrong, but quite considerable training. At the inception of the relationship, they have to agree to comply with all of the MCA's policies, procedures set out in the handbook, code of conduct, and properly analysed, those documents provide a framework of mutual promises relating to the services that he agrees to provide. Looking at this for what it is, it's a relational contract. And in our submission, it's somewhat artificial to suggest that
I'm never sure what is meant by relational.
well, there's an ongoing relationship and a hierarchical relationship as well.
Ongoing and hierarchical. Thank you.
I'm sure you didn't invent the term, but who did?
Can I turn to Professor Bulk, who
Perhaps he did.
Well, it's used by Mr. Justice Leggett in a different sense as one which gives rise to a duty of good faith. But I don't think that's the sense in which you're using it. Mr. Justice Leggett, that's what he then was when he
Anyway, that's what you
said
need.
that.
yes,
Whatever it came from.
apparently the term is coined, according to Professor Bulk, by Professor Ian McNeill, who's a North American scholar.
When did it first hit the English law reports?
My lord, on my feet.
My lord thinks it may have been Lord Leggett, as he then wasn't.
I mean, that's why I asked you, because I think, but I'm not sure, that it's used in various different ways. But you're using relational contract as meaning a contract governing a continuing relationship.
Lord, yes, there's an ongoing relationship, albeit intermittent.
Continuing, yeah. Okay. Thank you.
And
Sorry, whilst you pause, what you were telling us about what happens when a CRO joins, is that recorded as in the Employment Tribunal judgment, or is it uncontroverted fact? I mean, you said that he has to agree to comply with all the policies and procedures in the handbook as part of becoming a CRO.
I think Mr. Trolley showed us something yesterday.
I thought it was-
80 hours in the first year rings a bell.
yes, that's paragraph 10 of the tribunal's judgment.
But that's what's in the documents. But the process of becoming a CRO, I thought you were telling us,
you said
involves an express agreement
quite.
to abide by those terms. I was just wondering whether
The
that's reflected in the Employment Tribunal judgment or in some uncontroverted evidence. Or
My lord, in the code, sorry, it's supplemental bundle paragraph 8. We've already seen that the CRO must act in line with policies, procedures and processes. Number 6.
no, but you're misunderstanding me. I thought you were saying that I mean, this is what the code says that the CRO must do. I thought you were saying there was some event
Yeah, I thought so.
as part of becoming a CRO in which the CRO agrees that this is what he will do.
Well, my lord, it's page 17 of the handbook. And Mr. Tolley's already taken you to this. It's the volunteer commitment.
That's fine. I think my lord and I are having the same difficulty, which is, speaking for myself, I can understand why you would say that on inception he is taken to agree because he is joining on the basis of the volunteer book. But what I think both my lord and I thought you were saying was there was some moment where he has to agree, and I wrote down, at the inception of the relationship, have to agree to comply with procedures. And if my lord and I are on the same,
My lord,
I respectfully doubt whether that is an accurate statement.
my lord, I apologise. I was reflecting no more than the volunteer commitment.
So on joining, CRA will be given copies or digital copies of these 3 documents, and is taken after turning up for a certain amount of training and so on to have agreed to them. You don't have to
No,
sign and
I don't
hand
believe
something
that
in.
is the case. No, I've seen no evidence of it.
So it must be taken to agree to them, because if remuneration has been claimed, it can only be on the basis of an acceptance of the whole package, including the remuneration arrangements.
Precisely, yes. But the important point is this: when Mr. Groom, appreciate he's got to attend training, but also call-outs, it's somewhat artificial against the background facts to suggest that when he was on call, received a call to attend an incident, presented himself, provided his services, known that he would be remunerated, and the MCA allowed him to perform his duties, that it's a unilateral contract. We say that is a bilateral contract. But even if we're wrong, or the court doesn't accept that submission, even if it is to be analysed as a unilateral contract, it's immaterial. The reason I don't want to repeat the submission yesterday, we looked at the wording of section 230. Lim B applies to any other contract. Unilateral contracts are not excluded. And
I'm not sure that was Mr. Tolley's point. I think Mr. Tolley's point was, if it's a unilateral contract, it doesn't involve a contractual undertaking to perform work.
Lord, I was just going to turn to that pertinent point. Lord Justice Bean raised with my learned friend yesterday the submission that if someone was under no obligation to present for work, but attended in response to a promise that the organisation would pay, if they could not qualify as a Lim B worker, that would be a sweeping submission. In my submission, that is a submission which cuts down the scope of Lim B considerably. It's a submission which is unsupported by authority. And to make good that point, turn to, like your lordships, turn to tab 27 Uber. That's at page 457. Sorry, it starts at page 434.
I think yesterday I asked you, well, how does that come within section 230? And your answer was, well, undertaking doesn't have to be a contractual undertaking. Is that the only route you say which is available to a court to achieve that result, if you have what is genuinely a unilateral contract in which someone is simply invited to attend?
Well, my lord, perhaps before I take lordships to particular passages in Uber, what does goes back to the question, what does undertaking mean? And in my submission, it shouldn't be approached in the legal sense of a lawyer's undertaking, an undertaking provided by a lawyer.
Why not? It's in a statute.
Lord, that doesn't reflect the context. In my submission, it can apply whenever a worker agrees to perform work and that work is accepted. So take my Lord Justice Bean's example of the construction worker.
Agrees to perform work in a non-contractual sense, you mean? Obviously, if there's an agreement to perform work, then that will be a bilateral contract if it's a contract at all. I think what we're examining is a case in which there is a contract because it's an if unilateral contract, but it's a contract which is completed by an act by the individual, which is not performing a contractual obligation to undertake work, but is in fact undertaking work.
Lord, in that scenario, when, and using the construction site example, someone knows there's a £15 per hour, where an individual presents for work and the other party allows them to do it, that would satisfy Lin B, and that by their very actions the individual will be undertaking to perform
What action?
presenting for work and the other party allowing them to do the work, both with the knowledge of the agreed remuneration.
Well, I think the way you're putting it is it would be a bilateral contract, and that may be so. It just doesn't meet the point we're on at the moment, which is your alternative position, which is this is also a bilateral contract. But if it were a unilateral contract, it would be contrary to the whole purpose, see Uber, that it weren't caught. And I was just asking you, well, I understand that in purposive terms, but how does that work under the statute?
Well, undertaking, it's context specific, but if there's a unilateral contract where an individual actually presents or performs the work, that would be them undertaking to do the work for the purpose of Section 233B by their conduct or actions.
By undertaking to do the work in this context, you mean undertaking the work or agreeing in a non-contractual way to do it?
Yes. Yeah. All right. And we can see that by Uber and page 440, it's paragraph 16. We can see that the drivers were free to make themselves available for work by logging onto the Uber app as much or as little as they want and at times of their own choosing. And then paragraph 18 at 441. Page 441, paragraph 18. There's reference to various metrics, but just drawing out a few points from paragraph 18. The drivers were entitled to refuse to accept rides offered to them. Warnings were applied, and you can see just above G, they were also permitted to cancel trips that have been accepted, and then the sanction that would be imposed in serious cases would be deactivation, removal from the app itself. But then seeing how that's analysed at paragraph 90 at page 457. Lord Justice Leggett observes that they had a substantial measure of autonomy and independence, free to choose when, how much and where to work. And then at paragraph 91, over the page, well established, not disputed, the fact an individual is entirely free to work or not and owes no contractual obligation to the person for whom the work is performed when not working, does not preclude a finding that the individual is a worker or indeed an employee at times when he or she is working. So the key point here is, as in Uber, the Uber driver could turn their app on or off at any time of their choosing, But once they had turned their app on, they were undertaking work in respect of which they had no prior or contractual obligation to perform at all. So in my submission, that is the answer to the unilateral contract submission.
So are you saying that these were unilateral contracts?
Well, my lord, no, but testing the point that if an individual, and the MCA's point that if an individual is under no obligation to provide the work, they can't be a worker. Uber demonstrates that where someone is under no contractual obligation to undertake any work at all, they can still qualify as a worker.
That I understand. It makes clear you don't have to have an overarching contract. You can be a worker each time you undertake the work. But that's a different point, I think, from the one you're on at the moment, which is whether on those occasions when they do carry out work, that is a unilateral contract, which doesn't mean that on that occasion they are undertaking to carry out the work. I mean, if you say Uber was such a case on facts, then it would meet that point. But I wasn't sure whether you were saying that.
My lord, no, I'm not. The overarching submission is this in relation to ignoring my putting to one side my primary submission is that Mr. Groom's situation is a bilateral arrangement. In a unilateral contract situation, where the individual undertakes, performs, presents for duty, does the work, that is sufficient to trigger the LIMB provision in section 230.
Well, I can understand you pointing to the passages in Uber about the policy of relying on those to say, well, that ought to be the answer. But it doesn't really address whether it is and how you get there, because, as you say, these weren't unilateral contracts.
Your best point is to shove Uber under our noses and say there is no material distinction.
Lord, yes.
I mean, on the assumption, if we were to find that there was an intention to create contractual relations, I've got a little note to myself to ask Mr. Tolley when he stands up again. On the assumption that there was an intention to create legal relations, how does he distinguish Uber? It seems to me whether it's unilateral. It's tempting to worry ourselves about whether it's unilateral or bilateral, but that may not matter too much if it's Uber.
My lord, precisely. I think I said at the start that the unilateral contract analysis was a distraction in this case, but
Sure.
Well, perhaps you were wrong with my lord's point by saying what Uber shows is that it was a bilateral contract in that case, and if it's indistinguishable factually, it must be a bilateral contract in this case.
Let someone else work out how it works.
I mean, it is your primary submission that we shouldn't need to worry about what happens in unilateral contracts, because this isn't one of them.
Precisely, that is it. And Mr. Groom attending or being on call, even if he's got a choice not to accept the call out to duty, when he does, we are in Uber territory. And paragraph 91 addresses that. It's the focus of his status when he's actually performing a duty is the key focus. And on that basis, we say that the analysis in Uber is indistinguishable or reads perfectly across to Mr. Groom's situation.
And there were some obligations here, not just training, but isn't there a clause about responding to a certain proportion of call-out requests?
Lord, yes, that's set out in the code. Again, we've looked at paragraph 8. So, Your Lordship, opening it, It's attend all necessary qualification training, which the tribunal found after the first year was 16 hours per year. Attending at least 50% of official management-led exercises, tribunal found 26 hours per year. 50% of team-led voluntary practice, no clear finding, it varies between teams, and then a reasonable level of incident attendance. So those are the 4 key points which are measured over the metrics.
In Uber, there were penalties on drivers who, while they were on duty, had the app on, kept turning down requests. But as I recall, there was no obligation ever to be on duty, other than the obvious economic one. That if you're paying a lot for the app and paying for the car and so on, you'll rapidly go out of business if you never show up to work. But it was entirely up to the driver.
That is correct, yes. Paragraph 18 and 90 of Uber anchor those factual points. But the only final point to say in relation to the unilateral contract before I move on to ground 3 is that one would have expected Parliament to draw a distinction if they wanted to exclude certain types of contract from section 230, and the fact that it applies to any other contract would indicate otherwise, but can I say no further on that? Lord, I do apologise. I said I would address you very briefly on the Minimum Wage Act when I was dealing with the volunteer cases, and of course it slipped my mind. I won't address you too long on this. What section 44 of the Minimum Wage Act 1998 does, it has the general definition of worker. We don't have it in front of us, which mirrors section 230. So the same classes of people qualify for the minimum wage. But what it does do is contain a specific and express exception for voluntary workers so defined. And you can, without reading the whole of section 44 subsection 1, you can see in the second line that they do not qualify for the minimum wage if they receive, under their terms or are entitled to, no monetary payments of any description, no monetary payments except in respect of expenses actually incurred or reasonably estimated, and no benefits in kind other than subsistence or accommodation. Now, those exclusions have nothing to do with obviously this case, but what it does appear to be the case is that this exclusion has trailed some of the true volunteer cases that we've looked at and extrapolated from the cases that we've looked at who might be a genuine volunteer, and therefore Parliament has excluded those genuine volunteers from receiving the minimum wage. But we would rely upon this for perhaps a different purpose. What this demonstrates is that in relation to employment protection rights, where Parliament seeks to exclude a class, it makes clear and express provision from it. And we don't have that in relation to the factual circumstances relating to Mr. Groom or the type of contract that he's engaged on when he attends for work intermittently.
Is he not working for a statutory body? Is the CMA a statutory body?
My lord, sorry.
A worker employed by a charity, a voluntary organisation, an associated fundraising body, or a statutory body. Those are the categories who are
Sorry, yes.
within the exemption. It's not just concerned with volunteers.
No, it's not. But Lord, I'm sure Mr. Tolley would be able to address you on the exact status of the MCA. But for present purposes, if the MCA is a statutory body, then and assuming that Mr. Groom wasn't paid the minimum wage, he wouldn't fall within this exclusion. So
It may not help to look at the particular parties here. Your point is there are certain categories of people who perform work who, if they are only entitled to expenses, don't come within the national minimum wage, which presupposes that if that were not specifically catered for, they would be workers entitled to the national minimum wage, and therefore it at least assumes that someone who is only entitled to expenses is capable of being a worker. Not for these purposes, because they're specifically exempt, but they would otherwise be. Is that?
Lord, I gratefully adopt that analysis. Final ground 3, and this addresses the absence of mutuality of obligation outside attendances. Before addressing this substantively, it might be helpful to focus on or turn to the guidance in Windle and Secretary of State for Justice. It's at Divider 22, page 378. And the relevant passage that the MCA relies upon is at page 388, which Mr. Tolley showed the court yesterday. And at paragraph 23, Lord Justice Underhill rejected the submission that the absence of mutuality of obligations in between engagements adds nothing to the inquiry. 23 I do not accept that submission. The ultimate question must be the nature of the relationship during the period that the work is being done. It does not follow that the absence of mutuality of obligation outside of the period may influence or shed light on the character of the relationship within it. It seems to be a matter of common sense and common experience. The fact that a person supplying services is only doing so on an assignment by assignment basis may tend to indicate a degree of independence or lack of subordination in the relationship while at work, which is incompatible with employee status. But here's the key cautionary words. It's the last 4 lines of that paragraph. Its relevance will depend on the particular facts of the case, but to exclude consideration of it in limine runs counter to the repeated message of the authorities. But the key point to highlight, it depends on the particular facts. So it's a fact-sensitive question. And just to flag, this is the only ground where we raised objection to the MCA taking this point, just to flag that up. But in addition to objecting to it, I will address you substantively on it as well. The first point is, and I make it tolerably clear that I'm not criticising any of the MCA's legal team, but just stating as a fact, it was never argued before the Employment Tribunal or before the Employment Appeals Tribunal that the absence of mutuality of obligation outside of attendances meant that Mr. Groom was not a worker. It did not feature in the evidence or arguments put before the tribunal, and the tribunal did not consider it. So the tribunal, if the tribunal didn't consider a submission that wasn't advanced, that there can't be an error of law. But perhaps more relevantly, for the Employment Appeal Tribunal, in the MCA's answer, if it wished to raise an alternative or contingent basis as to why Mr. Groom wasn't a worker, it should have been flagged up in the respondent's answer, or at the very least it should have been the subject of submissions, and it wasn't. Now, just turning to one
But
authority.
the point that's in deciding whether the point is available or not and whether it was taken, the point is not that it would be determinative. The point is that it would be relevant that there was no overarching contract. And you're saying it was never suggested before the Employment Tribunal or the EAT on behalf of the agency that it was a relevant consideration that there was no overarching agreement. Is that your submission?
Lord, yes, essentially, that ground 3 is a enter stage left for the first time before this court.
Yes, but the ground 3 point is it's a relevant consideration. It's not put that it's a determinative consideration.
Yes, yes, but it's a relevant consideration, but it's advanced on the basis that in this case it should be determinative. Well, that's my understanding of how the ground is advanced. But in relation to the principles dealing with new points, of course the court's familiar with them, but can I just refer very briefly to one authority, Mayor and Burgess of Brent versus Johnson. It's tab 29, page 482. 482 is the start of the authority. The relevant passage starts at 492, my lord.
29.
Divided 29, and my lord, it's page 492. And see the heading of paragraph 37, it's Lord Justice Lewison, change of case on appeal. 37 permits the procedural objection to be made even though permission has been granted. 38 refers to the guidance in Singh and Das. Paragraph 16, the court should be cautious, allowing a new point. Paragraph 17, appellate court will not generally permit a new point to be raised on appeal if that point is such that either A, would necessitate new evidence, or B, had it been run below, would result in the trial being conducted differently. Pause there. We rely upon paragraph 17 for the reasons I'll come to, and that this is something that would require new evidence to have been adduced before the tribunal. Paragraph 18, we're not relying upon any of those points for the grounds of objection. Paragraph 39 refers to the spectrum of new points, and over the page sorry, at the bottom of 492, the spectrum of cases, at one end which has been a case where there's been a full trial involving live evidence and cross-examination in the lower court, and there's an attempt to raise a new point in appeal which, had it been taken at trial, might have changed the course of the evidence given at the trial or would require further inquiry. At the other end is a pure point of law. I'm paraphrasing there. So you need to consider what end of the spectrum this engages. Paragraph 40 refers to the guidance in Prudential Assurance Company Limited. And the first indented passage under 40, it's for the parties to define the issues on which the court is invited to adjudicate. And at paragraph 41, the reference to the appellate process is in general limited to review of the first instance decision. So that's the starting point that the parties are expected to put before the trial judge all questions both of fact and of law on which they wish to have an adjudication. We say that that applies here.
Yes, well, we know this, but two questions. What other evidence would you have wanted to adduce before the Employment Tribunal if this point had been raised? And secondly, as a fallback, supposing you do allow the point to be taken, better tell us what your submissions are about it. Otherwise, we're putting off this point to the next test case.
Excuse me, my lord. Of course, I did indicate I'll set out the objection, but I'd go on
Yes.
to address it substantively on the ground that permission is granted. My lord, just before I address your lordship's point about the evidence, can I just finish off with this authority? Page 493 from the indented passage, it's 7 lines from the bottom. Moreover, if the Court of Appeal deals with a point for the first time, it's neither a review nor a rehearing as contemplated. And then over the page to 494, and it's indented paragraph 25, 3 lines down, where the point, if successful, would require further findings of fact to be made. It's a very rare case in which an appeal court would permit a new point to be taken, and it goes on to say it would require a cogent explanation of the omission to take the point below. We say this is one of these rare case situations, and again, no, without being critical, stating as a fact, no explanation has been provided as to why it's only raised now. Now, as to what evidence would be required, well, my lord, it's clear I'm not taking you to the statements of the MCA or Mr. Groom at the ET level. That's not necessary. But what is clear, applying the test in Windle, the absence of mutuality between assignments, there are no factual findings recorded by the tribunal as to either how many times Mr. Groom attended, how often he refused calls to attend, how often he made himself unavailable for duty.
Unavailable, made himself available.
Made himself unavailable.
Thank you.
And in order for this court to be able to begin to address, I'll call it the Windle point, you'd need to have that evidence in front of you. Well, in order to determine whether or not the ET, well, I can't decide whether the ET erred in law in not considering a point that wasn't put, but it can't be right for a party just to come up with a point as an afterthought.
That's not an answer to my question, with respect. Why does the absence of these findings matter, given the findings we have got? What you actually need, what you're driving for, I don't understand yet. What you say is the disadvantage that you're subject to by reason of the absence of these factual.
My lord, perhaps I'll take it in 2 stages.
Please do.
Sorry. The first stage is if the MCA were to succeed on this submission, applying Windle on the facts of the case, you would need, at the very minimum, that evidence that I've just referred to.
It goes to the weight of the point. Your primary case, if I've understood it, is the fact that no overarching contract is entirely irrelevant because you're looking at it as to whether it's work on each individual case. And if you're right about that, then the Windle point doesn't have any traction. Your point is that if the Windle point does have attraction and it is relevant to look at whether there was an overarching contract, the weight that you give it may depend on the factual investigation as to how often, in fact, he performed the individual pieces of work. Is that
precisely that encapsulates its points. Now, to address Justice Stuart-Smith's point head on, why do we need further finding, etc., in relation to this point? This moves to the stage now if the court decides to entertain the point and disregards the objection. In our fallback submission, the Windle point, if I can call it that, is of little consequence because for really four reasons. First, as a matter of construction of the documents, we know that Mr. Groom had to comply with minimum attendance levels for prescribed activities, and those metrics were measured over a 12-month period. That's the first point. The second point, in circumstances where those attendance levels are stipulated by the MCA, it would be counterintuitive to suggest that Mr. Groom's compliance with those requirements reflected, to quote from Windle, a degree of independence or lack of subordination in the relationship while at work. So the short point is, if I can paraphrase that last point, the MCA can't set the minimum attendance levels. Someone complies with those, which it set and it dictates, and then rely upon its own levels to say there's insufficient mutuality, or that absence of mutuality negates worker status when he actually attends for work. The third point is that adherence or compliance with those requirements is the opposite of independence. In fact, it reflects a hierarchical relationship. And the fourth point is there was no evidence or any finding that Mr. Groom did not comply with those minimum attendance requirements. And I suppose the only point to add in respect of that, there are, taking the tribunal judgment as a whole, there are no real findings to indicate a lack of subordination in this relationship. Mr. Groom had to comply with the code, he was suspended from duty, and he was subjected to, which has got a different title, but he was subjected to a disciplinary procedure by the MCA. So for all those reasons, sorry, my lord.
I'm obviously missing something, and forgive me, I'm sure it's my fault. But in the absence of any of these findings, the assumption must go against the MCA, mustn't it? And there is no basis for an assertion that he did not comply with requirements, he did not turn up, so on and so forth. So surely, if this argument runs at all, you're in the best possible position. You haven't got any evidence against you to suggest non-compliance.
My lord, that is a shortcut, yes.
Well, I mean, in that case, I'm still missing something. I don't know why you're so fussed about it.
Well,
about the absence of findings.
When my lord says best possible position, you say we might have been in an even better position because we would have been able to show that he turned up every time and was doing it every other week. Yeah.
Lord, can I just check with Professor Gog? Unless I can assist further, those are my submissions.
Thank you very much, Mr. Brittington. Professor Bob? Mr. Tully? Yes.
Can I just deal with this procedural objection first to get it out of the way, and I'll get on to the points that really matter. But my lords have also got, I'm sure Brennan, the Johnson case is enough, but my lords have also got Hudson and Hathaway in the bundle, which summarises the points on the rules on new points on appeal. But I'm not going to take my lords to any of that. My lords are no doubt completely familiar with it. Can I just ask my lords to note that the response in writing to the objection about ground 3 is to be found in the MCA supplementary skeleton at paragraph 10. Supplementary Bundle 191. That provides all the references to the Windle citations all the way through the proceedings. So if my lords want to turn it up, it's Supplementary Bundle 191. So I haven't made a note of the tab. That will be tab 28. What I don't want to do is take my lords to 8 different supplementary bundle references in the course of a reply submission. I wanted to show my lords that it's all collated there in terms of what the MCA says was argued in terms of substance as to the question of...
I missed the paragraph numbers.
Paragraph 10, my lord, on bundle page 191. It's paragraph 10 of the supplementary skeleton.
Yeah.
If I may, so the primary response is it's not a new point, because it's always been inherent in the debate about what the quality of the contractual or non-contractual relationship is between Mr. Groom and the MCA. It may be that the point wasn't as articulated as it might have been, but the substance was always there. But if my lords are against me on that and consider that it is a new point on appeal, I say I should be given permission to run it, and let me explain why I say that it should be so. The first is that there is a close linkage between ground 3 and ground 2, to which there is no objection, because the essential submission is that what's relevant to the analysis of the position when people are working includes an analysis of the position when they're not, if that's the exercise one reaches in terms of this particular debate. And indeed, I could say the question could be looked at more widely, and you could say one ought to ask how far one looks at the context in deciding whether the participants in any arrangement intended to create a legally binding relationship. In other words, do you just focus one's attention on when they are at work, or if it's an intermittent performance of work, do you widen your scope and look at what happens in the whole of the relationship to answer the question of whether there was an intention to create legal relations? So I do want to acknowledge this point, my lord, which hasn't actually been made, but it's important that my lord should have it given the nature of this appeal, that in Windle, the distinction was being used for the purposes of differentiating between a contract of employment and a contract of self-employment. In other words, the degree of independence and or lack of subordination was being used as a differentiation between somebody who's an employee or a worker, properly so called, and somebody who falls outside that scope, either because for the purposes of employment they're truly working under a contract for services, or for the purposes of being a worker, they fall within the scope of the proviso, somebody who's not a client of a business or undertaking. So what I wanted to acknowledge to my lords is I'm trying to use the point slightly differently,
Yes.
which is to distinguish between the question of whether there's a legal relationship at all, or if there is, whether it's a legal relationship under which there's an obligation to do work. So I just wanted to spell that out for my lords in case it wasn't already apparent. But I do say that the reason for explaining it at any length at all is to make the point that there's quite a significant degree of overlap between what I'm calling ground 3 and the window point and the rest of ground 2. And I was tempted in the course of my presentation earlier yesterday to just wrap the window point into ground 2, but I felt that would be, as it were, presentationally disingenuous, because it had been separated out as a third ground of appeal. But my point is one of substance, that the two issues overlap. The final comments, if I may, my lords, and these are rather forensic points, but so is this objection, I would suggest, that Window was cited by my learned friend in the Employment Appeals Tribunal, and I've shown you the reference to his EAT skeleton, supplementary bundle, page 85, and in my submission it's rather rich, if I can put it like that, to complain that it's not open to the MCA to take a point on what Window decided in the Court of Appeal when the issue was there in the EAT. And then lastly, if I may, my lords, the dialogue that was had between my learned friend and Lord Justice Stuart-Smith. What additional evidence could there be? And the answer was given. Well, it's about how many days Mr. Groom worked and how many days he didn't work, and when he turned the points down. If I may, my lord, and with respect to my learned friend, my argument is different. It is not about a granular comparison on the facts between the circumstances, specifically focusing on the circumstances of Mr. Groom. It's a wider perspective point that one needs to look at the context in which work was being done by CROs.
What does that mean? All you're saying is there was no overarching contract, so there was no obligation to work on a particular occasion, leave aside what paragraph 4 says, but that was your overarching point.
Well,
and that is relevant to the question of whether there was an undertaking, a contractual undertaking to work on the individual occasions. But I think the point that's put against you is, well, if it's relevant, surely what is relevant is how often it happened, not just whether there was an obligation that it should happen.
I understand my lord's point. If I may respond in two ways. The granular response is this. Usually when one has to determine status, one has to determine it at a relevant point in time. And the problem with all of these arguments about how often somebody did something is that one's assuming knowledge, if you like, it's a contractual analysis, one's assuming knowledge that the parties didn't have at the moment at which they contracted. If on the other hand, one's got a job-by-job contractual situation, so every assignment is a separate contract, then I can see after assignment 100, the parties are deemed to have the knowledge of assignments 1 to 99.
Well, that's what we're concerned with in this case, aren't we? I mean, that is the nature of the contract that is being intended for.
I follow my lord. So that was the granular response. The wider perspective response is this, that it's not simply a matter of saying, look at the context. What I'm trying to get at is in trying to analyse the basis on which work is done, one is entitled to have regard, and I say one should have regard, to the basis of the overall relationship. And one distinguishes essentially between a case where there is a framework a contract.
Sorry to interrupt you.
Yes, of course.
If what's relevant to that is what the relationship is as a matter of obligation, then I can understand you saying, that's fine, we can see what the obligation is. If there's no longer a case for an overarching contract, there's no obligation, save to the extent we can see in paragraph 4. If your point is the context is how much or how little it did in fact do, then that's different. Now, are you confining yourself to the first of those?
Well, I have to confine myself to the first of them because in light of my Lord's correct observation in the course of debate, and my Lord Justice Stuart-Smith's correct observation, I'm stuck with the findings that there are. I can't manufacture findings that there aren't. And I run this point on the basis of the findings that there are. I'm not inviting trouble, suggesting, well, yes, of course, I'm entitled to make arguments about how often Mr. Groom did or didn't turn up, as my Lord Justice Stuart-Smith pointed out.
So without being unkind, is the Wendell point simply this? It is relevant that there was no obligation to attend on other occasions, subject to paragraph 4, and that's it.
Well,
and you give that whatever weight that carries as a matter of obligation,
well,
irrespective of how often it happened. Is that the submission?
It's not quite as brutally simple as that, my lord. If I can just add,
I know that was brutal, but tell me what more there is in it.
The nuance I would add is this: that there is a distinction between an arrangement, a framework arrangement, under which there is no overarching, there's no mutual obligation in the framework, but that when individual assignments are done under it, there is an acceptance of an obligation to do it. In other words, like the PG Mall example, I'm going to come back to to that particular case. But once the referee has accepted an assignment, that creates a contract under the framework arrangement. There are terms of that contract, and the referee is free to cancel up to the point of a certain time on the day of the match. But there is nonetheless a contract at that point. And that's a different type of structure from what I say we have in this case, is that there is, certainly in my submission, there's a lack of clarity about when the contract is said to come into existence. But let's say the contract is said to come into existence by the fact that the individual turns up at the emergency call-out. So that is said to be the relevant act whereby the assignment alleged to be contractual comes into being. But in my submission, what I'm trying to get at is there's a difference in kind and degree between those two scenarios. There is, on my submission in this case, there's never a moment under this alleged framework arrangement whereby clear contractual commitment comes into being, unless one tries to infer it simply from the things that people do. So I'm going to move on, my lords, to deal with.
But just before you move on, I'm sorry. Factually, what will happen is this right? That a CRO will be called upon to attend, and at that stage will explain either that they're going to or that they're not going to. So it won't just be turning up. At that stage, there will be assent to attending the particular incident or joining the particular course.
Yes, they'll say that they're coming. They'll communicate that they're coming.
Exactly. So it's and I think the case against you is it's not just turning up. It's at that stage they're agreeing to come and perform the work involved in the incident.
Well, I suppose one could analyse it in those terms, my lord. That the point that the CRO says, yes, I'm coming, then there's now a contract that comes into existence. And perhaps it comes to this then, my lord, once you drill down even further into that nuance, that there's a difference between an arrangement which is in response to emergencies of this kind and an arrangement like the referee's case, where there's, as it were, a fixed schedule of football matches and everybody knows in advance that one needs a referee on Saturday afternoon at 3 o'clock to, or whenever the game happens to take place, to be the referee. It's a much less structured environment, if I can put it like that.
If that's right, that may be the answer to what we were debating earlier. But the inside the moment, the thing which I'm not going to forget, which is the intention to create contractual relations. The call goes out. What we have, as you've just identified, is the call goes out. We need volunteers to come. And the CRO responds. So you could analyse it on the basis that at that point, there is an agreement by the CRO to undertake the work which has had a call put out. So that would be a bilateral agreement, and it would resolve the difficulty which I think we've been grappling with over the last 2 days, which is at what point does one have an agreement, and if so, does it constitute an undertaking to do the work? Am I going off piste?
No, I mean, what one has to interpolate into my lord's proposition is that the individual is undertaking a contractual obligation at the moment that he says he will come.
Yes.
Well, I specifically said leave on one side.
Yes, I apologise, my lord, of course.
And just to drill down slightly further into the facts, does it work that when a response to an incident is required, that a call or a message goes out individually to particular people in turn to say, Fred, are you available? Betty, can you do it? Or does it go out as a mass message?
It goes out as a mass message to the pool of potential available people. There is evidence before the tribunal.
There is evidence about this because there's a finding, which is that if, for example, they only need 2 people and more people respond, then the others are stood down. And that implies that there is this process of invitation going out and response stroke acceptance coming in. So you may get 15 people saying, yeah, I'm on my way, and 13 of them will be stood down.
In principle, of course, my lord. Then if somebody comes but can't make it for some reason, there's some supervening event, then the person in charge moves to the next.
So far as the evidence that we've got, it supports, I haven't done it particularly elegantly, but it supports the process that I've just outlined.
Yes, my lord. It's a general call to the pool of available people in the relevant locality. Then people will respond.
People will say, I'm coming, but you can't control how many say that.
And you may
and
stand
may end up with too many.
Quite so.
Yeah.
Quite so. And then those that are not needed may be asked not to come. They may end up having come anyway. But you know, these things can't always be controlled in the sort of environment I was talking about. So can I just address then first of all the points on Uber that have been made? There's really just one paragraph. I know my Lord Justice Stuart-Smith said the court will want to hear from me, but why Uber is different, and I'm going to do it in a very short way, if I may. Can I ask you to look in the authorities Bible? It's tab 27. It begins at 434, but the passage I would ask you to look at is 450. Paragraph 91, which my learned friend cited a number of times in writing and in oral submissions. Just by way of background, my lords, there was no issue in Uber that there was a contract. The question was it a contract with the passenger through the agency of Uber, or was it a contract with Uber? And that was the debate that was being had about the effect of the contractual terms. But there was no issue about the existence of a contract in the first place.
Well, I'm not sure about that. It was a while ago, but I thought Uber's case was that the only contract which the drivers had with Uber as a group was the contract to run the app on the car, and thus the only relationship was with the Dutch company. And we said in the Court of Appeal that was completely inconsistent with the fact that Uber London Limited was the regulated private hire vehicle company. And so the proposition that Uber London Limited were simply booking agents for the passengers was a lot of nonsense. I'm sure Lord Leggett put it more eloquently. It wasn't just a question of what were the terms of the contract in terms of the obligations.
I'm sorry, my lord, I didn't mean to suggest that. All I was trying to suggest was that the issue wasn't was there a contract or no contract, but with whom was the contract?
Oh yeah.
That's what I'm getting at. And obviously the findings and that ultimately were of course upheld by the Supreme Court.
Drivers weren't doing it out of the kindness of their hearts.
Quite so. But the ultimate conclusion was that contractual analysis wasn't the right starting place anyway. But insofar as it showed one anything, that wasn't the true analysis of the contractual position. There really was a contract with Uber between the drivers and Uber itself. But my 2 points, if I may, in response to the question of why our case is different from Uber, and if I can show you paragraph 91, as I say on page 458. There's 2 parts to this phraseology, and acknowledging, of course, that it's a judgment and not a statute. But first of all, His Lordship Lord Leggett here refers to the fact that the individual's freedom to work or not, and there was no obligation, contractual obligation when not working, does not preclude a finding that the individual is a worker or indeed an employee when he is working. It doesn't say it mandates a finding, it merely doesn't preclude it. In other words, it's not an answer to a contention that a person is a worker when he works, that he's not a worker when he doesn't work. The converse is not true, that because a person has a contractual obligation when he works, that he's necessarily a worker. And the second point is this, and this is perhaps the more fundamental point, that Supreme Court was here focused, as all the courts before were, on the situation of the question of the presence of a contractual obligation to the person for whom the work is performed when not working. Whereas my submission in the present case is that there's no contractual obligation even though when the person is working. In other words, the difference between the CRO and the Uber driver is that when the Uber driver is driving a passenger, he's under a contractual obligation to fulfill the journey. Whereas my submission in this case in relation to a CRO is that even after a CRO has said I'm coming and turns up, he's not under a contractual obligation to continue on the call out. He can change his mind at any time because in my submission he hasn't undertaken a contractual obligation to do any work. He has agreed to come, he's responded to the call. But the crucial distinction is there's no contractual obligation even when the individual is working. That's why I say the CRO's position is different from the Uber driver, is different from the referee. The referee can't walk off the pitch without breach of contract in the 20th minute. The Uber driver can't discontinue the journey halfway through, but the CRO can. The CRO can walk off the metaphorical pitch or discontinue the journey at any time. And that's not because he's got a contractual right to do that, but because there's no contractual obligation in the first place that requires him to do any more.
What did the employment judge find on this topic?
You'll find the decision of the employment judge on these points, my lord, so the decision is at tab 8 of your core bundle. There are two findings. Paragraph 30, if I can just find them for you. It's paragraph 33 on page 79 of your code. You can see in the second sentence there the contention on behalf of Mr. Groom. There's no overarching contract, but during the time a CRO is undertaking CRO activities, he is a worker. And this is the finding. However, it appears to me that the reasoning does apply. While a sense of public service might compel a CRO to continue to assist in an activity, particularly one which is a risk to health and safety of members of the public, there is no contractual right on the part of the respondent to require them to do so. That's the conclusion that the judge came to. And he goes on at the end of the paragraph to say, the claimant says, well, the respondent could terminate the membership, which he contends is the equivalent of a contractual right. But as a matter of fact, there is no contractual right to take any action at all. So those were the judge's findings on the question of whether the individual owed an obligation or whether there's a correlative right on the part of the MCA. And I'm conscious, my lords, that there's an element in which these are analytical conclusions rather than...
It's a conclusion. It's not easy to see anything in the judgment itself which form part of the reasoning for that conclusion. Or have I missed something?
Well, I take my lord's point in terms of what's actually contained in the decision itself. There's a reference to the evidence that the tribunal had before it, so one can have regard to the witness statements that were before the tribunal, and these points are addressed in the witness statements, and there was obviously cross-examination. But what I don't want to try and turn this into is some kind of factual investigation of what was and wasn't before the judge at the Employment Tribunal. My point is a more fundamental one, that it is a proper legal analysis, and I seek to persuade my lords that it's a proper legal analysis, that the CRO owes no obligation as a matter of contract to do anything.
Because there is no contract.
Because there is no contract, but even if there were a contract about the payment after the event, and I'm going to come to that separate point, my lord, even if there were a contract about that, there still isn't a contract which imposes an obligation on the CRO to do any work. So it's not the right kind of
while he is there.
even while he is there, my lord.
If that's what you say the finding is, paragraph 33, all I can say is that the employment judge might have expressed it more clearly, because it's a pretty drastic conclusion, and it's not part of the reasoning in Grayson. Grayson was not saying, as I recall, that when a CAB volunteer turns up unpaid except for expenses, there's no obligation to do anything while you're there. She could simply put her feet on the desk and say, you've got no right to expect me to do anything, because there's no contract. And you say that that's the same for CRO, despite a quite elaborate remuneration document, as well as the code of conduct saying you must respond to reasonable requests and so on.
Well, I'm going to deal with those particular points, my lord, but I do say in short, yes. And one sees it. It doesn't require too much reading in this sense, that Judge Cavaney plainly states in the sentence I read out a moment ago, that sentence begins 5 lines down, whilst a sense of public service might compel a CRO to continue to assist in an activity. In other words, the premise of it is that he started to assist. The continue to assist refers to the fact that he has turned up. And the question is he obliged to stay? Answer, no. There's no contractual right.
I may have been a little unfair on the Employment Tribunal judge. Although we were looking at 33 in isolation, it's really paragraph 31, isn't it? These are the factors that show no contract at all, which then feed into that, which then leads to the conclusion that whatever he's doing can't be a contractual obligation if there's no contract. But what I was putting to you, and I think you were accepting, is there's as an independent point, there's no other process of reasoning underlying that aspect of the not contractually obliged to do what he's doing when he's there.
That's fair, my lord, I accept that.
And is your submission founded on one, there being no intention to create legal relations, or is it founded on the terms of the agreement itself, which we've looked at a number of times, or is it both?
So there's actually 3 parts to it, my lord, if I may. But let me spell out. It's the first point. There's no intention to create legal relations in this arrangement. Alternatively, 2, if and to the extent there is an intention to create legal relations, there's no intention to impose an obligation on the CRO to do anything by way of attending a call out, or if he does attend a call out, to stay at a call out. And I suppose as part of that second point, my lord, and it may be an overlapping submission, 2A and 2B, if you like, that there is nothing in the Code of Conduct or Volunteer Handbook material which imposes that obligation.
That's my second one. That's on the terms of the agreement that we've got, which is represented by the documents that begin with the supplementary bundle. Your submission is that they, whether or not there's an intention to create legal relations, they do not impose any obligation upon the CRO to stay once he's turned up.
Yes. Either to turn up in the first place.
Bail out at any stage.
Exactly so, my lord.
I think you had another.
No, there's.
You came back and said there were 3.
Well,
I offered you 2.
Well, I think I probably just ended up with 2 parts in answer to my lord's point 2.
No intention to create legal relations, no requirement to attend, no requirement to stay once you have attended.
Yes. Yes, quite so. I'm grateful. But I see the importance of the interrelationship between, if you like, 2 and 3, which is why I started by saying there were 3 points. And
I think when you say no requirement to stay, you actually mean no requirement to do anything.
Yes, I mean, you could be there for a minute and then turn back. I mean, I appreciate, my lord,
Or do anything.
quite so. Yeah.
No, it's if there was an intention to create legal relations and we're into the second limb, you say on the documents they don't impose an obligation when he's there to do anything at all.
I do say that, my lord.
Yeah, I think you have to say that.
Yes, I mean, I make sure I think about my lord's question before I
No,
answer
but
it.
we in your submissions yesterday, you were keen to phrase it as, you know, he can go home any time, especially if it turns out that the incident takes too long, whatever. But I think actually your submission is as we've now characterised it.
Quite similar. I was trying to identify some realistic examples, you know, where people would behave in a particular way without just suggesting that they were being ridiculous. You know, somebody who turns up at the beach on minute 1 and then says, actually, I've changed my mind in minute 2 and goes home. I mean, that's not how people in the real world are likely to behave.
No, I mean, they may say, well, I'm not going to belay that rope because I don't think that's the right way of doing it, even though I've been told to do so by my supervisor. But you say that not required to do so on the face of the documents.
Not contractually required to do so.
No,
I do
at
say that.
this stage you say, at the second stage, where there's an intention to create legal relations, you say on the documents, not required to do so at all. I think you have to.
I do say that, my lord,
Yeah.
because what the premise of the unilateral contract is that it's, as it were, contrary to my first submission, that there is a contractual obligation to pay the amount stated in the remuneration policy, and or to pay the amount stated by way of expenses in that
For
policy,
what he does.
for what he does.
But he is able to determine what he does. That's your qualification of the unilateral.
He's not under any obligation in respect of what he does.
Yeah.
As a matter of contract. I mean, obviously there are.
Nor were the Uber drivers.
But purportedly, my lord, purportedly they weren't under any obligations.
No, they were under no obligation to clock on duty. That was the one. That was the one thing that was admitted.
Yes, and to that extent, there is an analogy between Uber in the present case, that the CRO isn't obliged to respond to a call-out. So up to the moment at which the Uber driver accepts the journey, or the CRO accepts the call-out, I accept Uber is indistinguishable from the present case. Hence my learned friends tried to mischaracterise my submission by saying, oh, well, there's no difference. But in my submission, the difference embarks at the point at which a CRO does say he's coming, by distinction to the situation where the Uber driver accepts the journey. The difference in the one is essentially whether there's a contract at all, and if there is a contract, whether it's a contract under which the individual undertakes to do work. So two other distinctions I'd like to offer, my lords, in terms of the debate on remuneration. First of all, between, on the one hand, remuneration and on the other, compensation. But there's a point that may or may not be important to my lords, but can I just show it in the Employment Appeals Tribunal's decision? It's at page 54 in your core bundle. It starts at paragraph 89, this section, under the heading remuneration. And you see the learned deputy judge summarises the submissions at paragraph 89. 90 to 93 deal with the question of automatic or non-automatic payment. And that just picks up a point that my Lord Justice Popplewell made in the course of debate. It couldn't matter to the legal analysis whether it was 2/3 or 90% or 2% of individuals who claimed. If it's a matter of legal analysis, these individuals are workers when they attend, then they're entitled to payment, and it doesn't matter whether they claim or not. That's point one. But the point I wanted to address in more detail is paragraph 94, where the learned deputy judge.
So is it your case that it might change?
Not at all, my lord.
No. So
Not at all.
if entitlement to remuneration is a consideration, it applies to everybody whether they take it or not.
I agree, my lord. I accept that. paragraph 94 is the point about the character of the payment. And it's the point that I wanted to pick up is 4 lines from the bottom. The handbook describes the payment, quotes, as compensation for any disruption to your personal life and employment. And then the learned deputy says this: a payment in compensation for interference in a person's use of their time is the essence of remuneration. And I wanted to take issue with that, as it were, as a matter of open articulation. Because, first of all, there's a distinction between, on the one hand, what might be characterised as a wage or salary, a reward for services rendered, and compensation for, as it were, disrupting somebody's life. And I appreciate there's a danger of over-literalism, but as it were, compensation for delay in a flight.
Well, it's not just any disruption to personal life, because the judge has quoted not just the handbook, but the part in the remuneration claims document above, which refers to claims for time. So he's specifically dealing with the disruption in a person's time involved
Yes,
in carrying out work.
they're quite similar, but there's two different points. One is the
It's not
purpose.
like disruption for a flight.
Well, if I may, my lord, there's two different points. There's the purpose of the element of remuneration, and then there's the more detailed provisions in the remuneration document about how it's calculated. So there are different types of remuneration, whether it's for attending a call out or whether it's for attending a form of training event, and so on. And the remuneration document gives all those details. The important point is, what is the purpose of the payment at all, however calculated and however administered? And that's what the handbook is getting at, that it's compensation for disruption to personal life and employment. I mean, I take my lord's point that a flight case is different, but all I was trying to get at, my lord, is that it's not compensation for an interference in the sense of an unwanted interference in a person's use of their time. In other words, the flight delay case is a situation where the individual doesn't want to be sitting in the airport, but they're compensated for the interference in that sense. Whereas what's happening here is that the individual is willingly coming without any sense of prior obligation. And I say that the idea is it's a recognition of the fact that they've upended their personal life, which they could have been spending doing something else, or their ordinary working life, their regular working life, and they could have been sitting at their ordinary work rather than.
Could have been earning elsewhere. I mean, they may be self-employed.
Yes, they might have been earning significantly more elsewhere. If they're earning a significantly higher hourly rate than the national minimum wage, then it's not in the sense of true compensation for their loss. It's a recognition of the fact.
And this is to avoid the conclusion that it is the classic work covenant of being paid for the work you've done.
Yes,
That's the point.
that is the point, my lord. That it's not, in my submission, analogous, or at least sufficiently analogous to the wage work bargain metaphor that my learned friends have put forward, because it is not being premised on here is an hourly rate for a contractual entitlement to an hourly rate in return for your time. It is, in my submission, a non-contractual arrangement under which, if the individual does turn up, then they can put in a claim for their time, and that for the fact that they've spent the time. It's not calculated on an exact basis, because as my lords have seen from the remuneration document, it's worked out in blocks of time. You turn out, there's a 3-hour block. If it continues, then there may be another block of time, or if it gets interrupted. Pardon me, my lord?
So what?
No, but the answer to the so what is that this doesn't translate to somebody working on minimum wage on an hourly basis. It's not like the fruit picker who's engaged to spend 6 hours or however long picking the line of fruit takes.
If it is in fact calculated on an hourly basis by reference to the amount of time spent, to describe it as compensation for disruption to personal life and employment is not really an accurate description. It's completely unrelated to the extent of disruption to their personal life or the extent of disruption to their employment. None of that forms any part of the inquiry or as to the calculation. Now, that may be a useful way of expressing it in the documents if you don't want to treat it as a wage, but that can't disguise what it actually is, can it?
Well, plainly, if my lords were to form the view that that is what it actually is, that it's a wage, then I appreciate no amount of word.
No, what it actually is an amount of money paid by reference to the amount of time spent on the activity. And that's what the documents show. That's how it's calculated. Leave aside whether you characterise that as a wage. That's what it is. It's not an amount of money calculated by reference to a measure of the disruption of personal life or the measure of disruption to employment elsewhere. That's the only point I'm putting to you.
Well, I accept the way my lord puts it. I mean, what I would say by way of addition in response is that the handbook explains that it isn't meant to be a precise measure. It is meant to be a reflection of, in broad terms, of the disruption. But I accept my lord's point. That's the way it's calculated.
But that's whether it is a broad measure of that or not is the point.
Well, quite so. It's not a measure in any sense at all. It's a recognition of it rather than a measure of it, if I can put it like that. My lord.
Yeah.
But what I would say, my lord, of course, and it's perhaps implicit in the question and answer just passed, that the word compensation in the handbook is being used in a loose and non-legal sense. It doesn't purport to be, as it were, recompense for a legal wrong done to a person. That's that sense of compensation.
Clearly not.
So the next point I wanted to deal with was the distinction between expenses and remuneration. Because in part of my learned friend submissions, he was understandably in my submission keen to avoid an outcome where even the right to a payment of expenses, the contractual right to the payment of expenses, would make a person a worker. And he sought to set up a distinction between what he called a volunteer and a true volunteer. In my submission, one needs to be a little bit careful about that kind of distinction, whether there's any foundation for it in the first place, or if there is, what the basis for it is said to be. In other words, what our friend seemed to be saying was, a true volunteer is somebody who gets no more than expenses, whereas there can be volunteers who get more than expenses, and therefore they're not true volunteers. And as I say, one needs to be careful because, first of all, there isn't some universal right, absent contract, to reimbursement of expenses. There's no general statutory principle that a person is entitled to expenses incurred in the course of work. So if there's a contract along these lines, if you do some work for me, I will reimburse your travelling or subsistence expenses. That's in my submission just as much a contract as one which says if you do some work for me, I'll pay you £15 an hour, because there's consideration, and if the work is done, then the contract has been completed. So what I'm trying to get at, my lord, is that the consideration question is not the touchstone, because there can be consideration in both types of volunteer or true volunteer case, using my learned friend's language. And I would add, the value of the consideration can't be the test, albeit it might be a relevant factor. I mean, just coming back to the point I tried to make yesterday, if there were a ridiculous amount that was being paid and purported to be described as a gratuity, then a court or tribunal would be understandably sceptical about that. But there are in the cases other forms of consideration, like in Grayson, the indemnity against claims for negligence. They're not all about expenses. And so, and some of the cases refer to consideration in the form of food or drink. It's not particularly great value, but there's still some value. So all I'm trying to get at, my lords, is that it is not a viable distinction for the purposes of Section 233 in dealing with who are workers and who are not, to ask oneself, is there consideration beyond expenses? And one's interpolating far too much in my submission into the words of the section.
But you do accept that the extent of any, I don't want to use the word remuneration, the extent of any payment in excess of expenses may be a relevant
Extent
consideration.
of any benefit conferred on the individual who does the work is relevant, of course it is.
And is it relevant in this case that it was set at the national minimum wage? Or is that wholly irrelevant?
Well, I've already said that the amount is a relevant consideration. It's a factor for any court or tribunal. I accept that, my lord. But
In fact, the amount in this case was actually set by reference to the concept of a wage. Is that relevant on this issue as to whether this was a wage work bargain?
I could see how it could be said to be. I would say the reason I would say no, my lord. The reason I would say no is because it is simply a convenient measure of what would be the least amount a person might get for their time if they were working. It doesn't, however, reflect anything like a wage for the kind of work that is being done. In other words, my lords, the minimum wage is merely a floor. It is not some kind of scale rate which people might get in particular industries, perhaps with a greater union involvement. And of course, there are two different kinds of, in broad terms, CRO. There are the CROs who are employed and whose employers release them to do work in the form of CRO. And there are those who don't have a regular employer, either because they're self-employed or because they're not employed at all. They're retired or they're a student, for example. The great majority, and there was evidence in the tribunal about this, and Mr. Meisen's witnessed it, but the great majority of CROs have regular employment. So they're already earning a living as employees. So the point I was trying to get at, my lord, is that the element of payment that comes from the MCA is in no sense, at least typically, a form of living wage that an individual needs in order to get by. That's the only point I wanted to try and communicate, my lord. In answer to my lord's point, is it significant that it's set at the level of the minimum wage? The answer is in the context of the body of CROs, as has been the case for many years. It isn't a reflection of some kind of wage work bargain, given that the individuals in question already have whatever they are earning from their regular employment. This is by way of addition rather than by way of replacement or supplement. I don't mean supplement, by way of addition, replacement for the wage that they've lost or anything like that. I just wanted to refer, my lords, by way of note, I'm not sure your lords need to turn it up again, but in Murray, the Employment Appeals Tribunal certainly saw the arrangement to pay expenses as contractual. And the reference for my lords is paragraphs 11 and 12, authorities under page 187. What His Honour Judge Wilkie, as he was, found there was that the right to payment of expenses was a matter of contract. The question, however, was and therefore there was a contract. The question was whether it was the right kind of contract.
Well, I thought there was common ground on this, that one can be terribly sophisticated about it. If somebody just turns up for work at, say, a charity shop as a volunteer, and there's no express agreement to pay expenses, then there's no right to recover them. If, on the other hand, the charity shop, whether in writing or clearly orally, has said, if you come and work at the shop, you don't get any payment, but we will reimburse your train fare, bus fare, and they don't, then it would be a breach of contract at common law. How you make a small claim viable is another matter, but as legal analysis, it would be a breach of contract.
They're quite similar, but the point is that doesn't help one to distinguish between an intention to create legal relations case and a no intention to create legal relations case.
No.
The point is that contractual promise to pay expenses makes a contract. The question remains, is it a contract under which the individual undertakes to do any work?
Oh, sure.
To paraphrase.
That's right.
So, I mean, essentially what I wanted to do was summarise my submissions on this subject with 2 points. That the first of all, the nature and extent of any payment or other form of benefit conferred may be an indication that there's a contractual right to payment. And possibly also of a correlative legal obligation to work. But, and this is the second part of my point, it isn't necessarily so. And there may be, and I say there are here, other factors which indicate that the overall arrangement is either non-contractual in its entirety, or at least non-contractual in relation to the doing of any work. I made my submissions already about why I say those things, but I just wanted to try and draw the threads together and make it clear what I'm saying ultimately in light of all these details. So I'm very nearly finished, my lords, you'd be pleased to know. Then I just want to deal with the general topic, if I may, of rights and correlative obligations in this context. So my learned friend referred a good deal to what he said was the mandatory language of the handbook and the code of conduct. And I would say, by way of general response, that's all overlaid with the introductory words that it's, as it were, non-contractual. But let me address the premise that what's being asked of the CRO and the code and the handbook is mandatory in legal terms. That these are legal obligations on the CRO. And it follows, indeed, as my learned friend contended, that the MCA would have a claim for breach of contract against the CRO if he didn't act in accordance with those putative requirements. So the example he gave was failing to avoid damage to MCA property. The reference for my lord is supplementary bundle page 10, paragraph 23. Now, on my learned friend's case, it's obvious why this has to be so, because one rarely gets legal rights in one's favour, at least in the contractual context, without a correlative legal obligation. Possible, but it's unlikely. And so what my learned friend has to accept on his case is that in return for a legal right to receive payment, the CRO must be under a legal obligation to turn up, and that all the legal obligations, indeed, in the handbook and the code of conduct, you can't pick and choose. Now, I want to be clear about three things. First of all, on the MCA's case, there are no legal obligations on the CRO. It's not merely a matter of the MCA having legal rights and choosing not to enforce them. The MCA's case is that those rights don't arise in the first place. And I wanted to pick up a point that my Lord Justice Popplewell raised with my learned friend in the course of debate, that it would be rather unlikely for a CRO, or indeed any putative employee or worker, to agree a no-fault basis of liability for damage to property.
Well, that may be a reason for construing that clause as not meaning no-fault liability as a matter of contractual obligation, rather than saying it doesn't involve a contractual obligation at all.
Well, quite so. I mean, there was a suggestion that one could read in the word, my learned friend suggested one could read in the word willful, and my lord pointed out, well, you wouldn't need to do that because that would be a matter of law anyway.
Well, contracts are full of terms that replicate the position, which would exist even if they weren't there.
Quite so, my lord. And so I suppose one could interpret the word negligent. One should not negligently damage coastguard property. But again, one's having to do quite a lot of work to turn what is, in my submission, essentially a non-contractual.
But you've picked on that one, but are there any other examples? I mean, what's your best example of a term which you say wouldn't make any sense in the real world if it were a contractual obligation placed on the MCA?
The example my lord picked was a perfectly reasonable one, but let me give my lord another one, if I may. So if one turns it up, it's supplementary bundle page 10. Paragraph 19, if I can pick on that one, given that this sort of activity is perhaps a bit more prevalent in the current days than perhaps it would once have been. criticise or complain about the MCA openly in public in any media, including social media. I mean, could it really be said that the MCA could get an injunction against, leaving aside the particular issue of freedom of expression, but
You can't leave that.
Well, no,
You
but-
can't leave that aside, and you couldn't leave it aside in interpreting the scope of that
well,
as a contractual obligation.
no,
could you?
but my lord, the point would be that there is a contractual obligation capable of being enforced at all of that kind.
Yes.
To not criticise or complain about.
Well, there may be circumstances in which that would have content which was entirely consistent with and proportional to the freedoms in the ECHR. Why, if that is how it is to be read, why is that a surprising or unreasonable term? I thought it's might be said to serve a sensible purpose. That you don't go slagging off your quotes employer or those for whom you are carrying out quotes work.
Well,
It's not your best point, Mr. Toddy. I think one could find some of these 26 sub-paragraphs which are less likely to carry legal implications. Let's not go down the freedom of speech rabbit hole.
Well, very good, my lord. But what I wanted to say by way of general point, if I may, about this whole topic, is that this entire list is in the nature of, as it were, do's and don'ts that one might find in relation to any hazardous activity, where health and safety of both the individuals who are doing the CRO work is in question, and the individuals, as it were, for whom they're doing it, the people who are, as it were, at sea. It doesn't require, in that context, that there should be contractual rights and obligations as between the CRO and the MCA. Two very quick points. Well, I'm conscious we're about 2 minutes to 1 o'clock, so I must finish. Our other friend focused significantly on the training requirements, which he emphasised at paragraph 4 on page 8. But can I make 2 broad points there? First of all, one sees in relation to 4D that it is non-specific. It's a maintain a reasonable level of attendance and incident attendance, and there was evidence in the Employment Tribunal about what that meant in practice, and there was a certain amount of debate about how often or otherwise a CRO might be expected to respond. But the point is there was no fixed proportion which was said to be reasonable in every case or across the board, and it was a matter of, as it were, legitimate discussion rather than something that would be enforced strictly, whatever the percentage was thought to be. So that's point one, that there's no strict measure. The second point is this, that where there are quantitative measures, A, B, and C, that all relates to training. And so even if those were obligations in relation to training, that wouldn't be a contract to do work, that would be a training contract. And there are cases, and my lords have got Murray in the bundle as an example. The reference is paragraph 14 of Murray bundle, page 188, where the Employment Appeals Tribunal said, well, we'll have to remit because we'll have to find out whether this is a contract to do work or a contract for training. Because if it's just a contract for training, then it isn't a worker contract. And just by way of more recent instance outside the concept of volunteers, one's had cases like Varnish and British Cycling, you know, where the issue is it a worker contract or is it a training contract? My lords haven't got that case in the bundle, I apologise, but the reference is 2021 ICR 44. And we've also handed in, but I won't take up time with it now given the time of day, we've handed in a case called Edmonds and Lawson.
Oh, pupil barrister.
Quite similar. I expected my lords would remember it. And the conclusion in that case, first of all, that there was an intention to create legal relations, but it wasn't a contract to undertake any work for the other party to the contract, because there was no obligation undertaken to do any work. It was an obligation. Rather, it was a kind of training contract. It wasn't a contract of apprenticeship either, but that's a different point. but it's just to try and reflect that there can be arrangements under which there are some obligations. They're just not obligations to work. Finally, I appreciate that I'm pushing my luck. Section 44 of the National Minimum Wage
Yes.
Act. Two points, if I may, in response. First of all, none of this assists in this case because, my lord, the MCA would not come within Section 44. It's not a statutory body. It's simply an agency of the Department for Transport, which is not itself a statutory body either. It'd be a bit surprising if, as it were, a government department came within the scope of a statutory body for the purposes of Section 44.
Yes, I understand.
So, I mean, I do understand the, as it were, value of the more general point that Section 44 reflects a nuanced judgment about the circumstances in which benefits conferred on a volunteer do not turn them into a worker for the purposes of national minimum wage entitlement. I just wanted to indicate that in the context of the present case, they're not going to assist either way. And my lord, for my lord's note, the point did come up in the EAT.
Yes.
See Court under page 55, paragraphs 99 to 102. So conscious that I've probably pushed my luck further than I legitimately can. I'm going to pause there.
Mr. Tolly, thank you very much. Thank you all very much for your great assistance. We'll, of course, reserve judgment. We will send out a draft in the usual way, on the usual terms, which is it won't be a draft in the sense of inviting further submissions. On the contrary, it'll simply be for correction of typos and factual errors and the like. Any submissions as to consequential matters should be in writing. The contents of the draft judgment are confidential to the parties and their legal advisors. And in the case of Mr. Groom, if there are trade union officials or legal advisors actually giving instructions to Mr. Britton and Professor Bogdan, they're included as well, but otherwise is confidential until promulgation on the National Archive and so forth. Thank you all very much for your very high quality assistance.
All rise, if